In family law, once you file your petition for divorce, during that 60 days, if you are not able to agree on a settlement or come to a settlement, whether it's property, whether it's child support, whether it's dividing the debts, who gets the house, then what's going to happen is, in most instances, the court is going to order you to mediation. And mediation is a process by which both parties, along with their attorneys, sit down with a or a neutral third party who oftentimes is a lawyer and in some instances can be a former judge, who will then mediate the case. That person will kind of go back and forth between the parties and their attorneys and see if they can't work out some of the disputes that have occurred with regards to property settlement, with regards to child support, with regards to custody of the kids, etc. That's just another vehicle that the court system has put in place to try to resolve cases outside the courts. As you know, the courts are inundated with cases constantly, and there's backlogs because there are so many divorce cases or so many litigation cases. So they send you to this mediation process to help you resolve those disputes. In most instances, those disputes are resolved. Very seldom do you have a divorce case that will go to trial. I think it may be in the uppers of maybe 5 or 10% of all divorce cases end up in full-blown trials. So it gets resolved during this mediation process, which is very cost-effective, because if you go to trial, or if you take a case, a divorce case, and you start the litigation process through discovery, depositions, etc., your case can be $50,000, $60,000, and in some instances well over $100,000 just to get a divorce.